5, 4, 3, 2, 1, start.
The main facts are being taken from Criminal Revision number 23 of 2018 full stop. The common gamut of facts as can be culled out from the pleadings of the parties are that the respondent is the owner of the two properties mentioned in the petition situated in the buildings of Messrs. Purnima Square Private Limited, Suhani Mandi, Tehsil and District Ludhiana full stop. The petitioner had taken the top floor and the fifth floor of the premises on rent from the respondent / landlord via two separate written agreements dated 2 November 2015 full stop. The rent for the top floor was agreed at the rate of rupees 1 lakh per month along with 6% interest per annum full stop. Stanza. The rent for the fifth floor was agreed to be rupees 5 lakh per month with a similar increase of 6% per annum full stop. The duration of the said tenancy was fixed to be 9 years full stop. As per the allegations, the petitioner paid the rent for 5 months with intermittent defaults in case of premises on top floor and thereafter defaulted in payments full stop. Almost similar has been the position qua the fifth floor full stop. The respondent alleges that the verbally requested the petitioner for making the payment of defaulted amount full stop. After request, some payments were made full stop. However, again the default was started and is still continuing full stop. As a result, no rent is being paid to the respondent full stop. Although the petitioner as a tenant is enjoying the property, however, he has not been paying even the electricity charges or any other taxes and charges leviable by the government full stop. Stanza. On the contrary, the respondent is being forced to pay the GST leviable on the rent, electricity charges and other charges leviable by the government full stop. As a result, the respondent had filed two separate petitions under the Punjab Rent Act 1995 bracket start. In short, the act bracket close for recovery of possession from the petitioner for non-payment of rent as well as claiming his personal requirement so as to expand his business full stop. The petitioner / tenant appeared before the rent authority and filed the written statement full stop. However, the petitioner also filed application stating that the same to be under section 20 of the act, in which it was prayed that since the respondent had not given him the notice in the prescribed form as required by section 20 of the act, therefore the eviction petitions itself were not maintainable and therefore observed to be rejected full stop. Stanza. But the rent authority dismissed the same in both the petitions wide order dated 25 October 2017 full stop. However, since the petitioner had also filed the written statement, therefore taking into consideration the pleadings of the parties, the rent authority framed the issues for its determination wide order dated 13 March 2018 full stop. Aggrieved against the above said two orders dismissing his applications for rejection of the eviction petitions passed by the rent authority, the petitioner filed two appeals before the appellate authority questioning the order passed by the rent authority full stop. Similarly, aggrieved against not ordering immediate eviction of the tenant and framing of issues in both the petitions, the respondent also preferred two appeals before the rent authority full stop. Stanza. Therefore, the appellate authority considered four appeals, two filed by the petitioner and two filed by the respondent full stop. The appellate authority dismissed the appeals filed by the petitioner and held that the application for rejection of the eviction petitions had rightly been dismissed by the rent authority full stop. In the appeal filed by the respondent, the appellate authority held that since the rent has not been paid by the tenant and the default continued even during the pendency of the proceedings, before the rent authority. Therefore, the tenant was liable to be evicted for non-payment of rent, full stop. Hence, the appeals filed by the landlord were allowed, full stop. However, the matter was remanded to the rent authority to grant an opportunity to the petitioner to pay the up-to-date rent to the respondent, failing which the rent authority was directed to pass the eviction order without carrying out any further proceedings, full stop. Stanza. It is against these four orders passed in two different eviction petitions that the present four petitions have been filed by the petitioner, full stop. It deserves mentioned here that it is not even disputed that the petitioner has not paid any rent after filing of the eviction petition before the rent authority, full stop. Before the appellate authority also, no rent was paid or deposited by the petitioner, full stop. Before this court also, the matter has been pending for about 2 years, but no rent has been paid or deposited by the petitioner, full stop. Hence, during the entire period of litigation, the petitioner has been occupying the premises without payment of any rent, full stop. Before proceeding further with the arguments, this court had asked the petitioner whether he was ready to pay the rent and its arrears to remain the premises, full stop. Stanza. The counsel for the petitioner had sought time to get instructions in this regard, full stop. However, on the next date of hearing, the counsel for the petitioner submitted that he has the instructions to say that the petitioner is not in position to pay any rent because the petitioner has gone bankrupt, full stop. These facts and the assertions by the petitioner itself disentitle him to continue in possession of the premises in question for even a single minute, and the petitioner is liable to be evicted from the premises with immediate effect, full stop. However, since the petitioner has raised certain legal questions, therefore it is appropriate that this court considers the same and then consider the matter, full stop. Stanza. Arguing the case, counsel for the petitioner has submitted that both the courts below have gone wrong in law in dismissing his application for rejection of the eviction petition filed by the landlord as per the mandate of section 20 of the act, full stop. It is submitted by the counsel that the act prescribes a mandatory condition of giving notice by the landlord to the tenant in the prescribed format as given in schedule to the act, full stop. If the same is not complied with, then as per subsection 1 of section 20 of the act, the rent authority was restrained from passing any order of recovery or decree for possession of the demised premises, full stop. Stanza. Hence, the condition of the issuance of notice is mandatory for maintaining the eviction petition, full stop. Therefore, this was a duty cast upon the respondent to comply with this provision, full stop. Counsel has further submitted that the agreement claimed by the respondent is in writing, therefore the same was required to be registered as per section 4 of the act, full stop. Since the agreement has not been registered, therefore the same is not admissible in evidence as per section 49 of the Registration Act 1860, full stop. Since section 4 of the act starts with non-obstante clause, therefore neither such an agreement has any legal value nor can the same be led in evidence by the respondent, full stop. Stanza. Counsel has further submitted that during pendency of the petition, the landlord has discontinued the facilities available to the petitioner, which is against the mandate of section 19 of the act, which prescribes that even if there is a default on the part of the tenant, landlord could not have discontinued or disconnected the amenities available to the tenant, full stop. Counsel for the petitioner has further submitted that the appellate authority mainly has gone by the fact that the petitioner has admitted the pleadings raised by the respondent in the eviction petition, full stop.